Good afternoon. I'm Cassandra Hurt with the Village of Oak Park's Community Relations Department, and I am here today to present on the Just Housing Amendment to the Human Rights Ordinance for Cook County. What is the Just Housing Amendment? On April of 2019, the Cook County Board of Commissioners passed an amendment which prohibits housing discrimination based on an individual's criminal background history. It also requires landlords to perform an individualized assessment on the criminal conviction history of the applicant prior to denying them housing. Let's take a look at this process. Step one is the pre-qualification. Pre-qualification, this is your normal application paperwork where you're obtaining information and supporting documentation for all applicants. This is not where you're doing a criminal background check because you can no longer do both a credit check and a criminal history check at the same time. If the applicant meets the step one requirements, then step two is optional. Step two will be the criminal background check. It's optional because the Just Housing Amendment does not require the criminal background check. However, as I've said in my previous recordings for fair housing training sessions, you want to be consistent and you want to document whatever it is that you're doing. Step two is a criminal background check. If you are doing a criminal background check, remember it's only screening for the last 3 years for criminal convictions, not criminal arrests. Any convictions older than 3 years may not be used to deny a housing application. If the conviction is found, then the landlord must conduct an individualized assessment. Also, if there's a conviction found, the landlord must send a copy of the criminal background report to the applicant within 5 days of receipt. And the applicant has a 5-day period to provide information to dispute the relevancy or information in the criminal background history. We're going to talk about that again in a few minutes. What does the assessment look like? What is included in the assessment? The assessment should be documented for future references, but the types of information and questions that you want to know in the assessment is the nature or severity or the recency of the conduct of the criminal history. How many convictions has the individual had? How much time has passed since the last or most recent conviction? Is the person being rehabbed or rehabilitated? Are they working on any trainings? Are they working on any certifications? Are they part of any organizations? Now, good, positive organizations that are moving them forward. Are there any other additional relevant factors that you need to consider? The individualized assessment is where you will need to know and have that information. As I mentioned earlier, again, I cannot stress enough that you need to make sure you're documenting and being consistent in your good practices and your processes. So a review of the screening process. Step one is pre-qualification. Person is applying for a unit. You're receiving information that verifies what they are saying on their documents. If they are approved or they qualify, then the landlord can issue an approval at that time and offer a unit, or the landlord can go to step two. When I say landlord, I'm also talking about the agent can go to step two. Step two is the criminal background check. Remember, you're only screening for the last 3 years of criminal history based on convictions, not arrest records. Based on the criminal background, the landlord is going to do an individualized assessment. The person will be notified of the criminal background record. If the applicant passes both checks, the pre-qualification and the background, or the individualized assessment, and the landlord is satisfied with that information, they may offer the applicant a unit. However, if the applicant does not pass step one and or step two, then the applicant may be denied. The applicant has a right to dispute the denial. What is that dispute process? If the applicant is disputing, they must receive a copy of that background check within 5 days from the date of receipt from the landlord, that the landlord gets it. The applicant has 5 days to produce any information as to the accuracy or relevancy of the background check. Once received, or while that is going on, during that time period, remember the landlord or his agent is doing individualized assessment. Once the information is received back from the applicant about the dispute, the landlord or their agent has 3 days to respond to the applicant, whether or not they're going to approve or deny. If they are denying, all denials must be in writing with an explanation as to why. The applicant has a right to file a complaint with the commission if they feel they've been unlawfully denied. There are some sample languages for the different notices that will go out. Let's take a look at those. This first notice is sample language for a notice that goes out with the criminal background check, where you are notifying them, hey, here's your criminal background. This is what we found on that. You have an opportunity and a right to dispute the relevancy of this information. If you notice, you want to make sure that this is on your letterhead. All notices will go out on your letterhead, and they need to be sent back to you as the landlord or the agent. The next 2 slides shows sample language for notices that go out once a person was approved or qualified for a unit, but they did not qualify with the background check. As you will note, the applicant has notice on the bottom of the form that they have a right to file a complaint with the Cook County Commission on Human Rights if they feel like they've been unlawfully discriminated against based on their criminal history. We've covered quite a bit of information in such a short period of time, so I know you have plenty of questions. What I've done is I have a list of the frequently asked questions. I want to go over the questions that tend to be asked the most and the ones that are overlooked and may get you in trouble if you're not paying attention. Quickly, can having a criminal background result in automatic denial of a housing application? No, it cannot. Remember, you're only considering the criminal history on convictions for the last 3 years, not arrest. You cannot say no sex offenders or something similar when advertising for the unit, but you can say no registered sex offenders or persons under a current child sex offender residency restriction, which is more of the legalese that you can use. You can no longer say no felons, no sex offenders, no convicted drug dealers, no criminal history, no arrest history when you're advertising. And again, as I mentioned, landlords are not required to conduct a criminal background check. But I will say again, you want to be consistent with your practices and treat everyone the same. If there were arrests but no convictions, those arrests cannot be used against the applicant to deny housing. Landlords are no longer able to include a checkbox, even asking about a criminal background. Again, criminal background checks and credit checks are not performed at the same time in step 1. Step 1 is for pre-qualifying on the application. Do they meet the qualifications for the unit other than with their criminal history or criminal background? And here's one for those that are concerned about your business. You do not have to hold a unit off the market while the dispute is in progress. You can continue to show the unit to other qualified applicants. There are penalties for violating the Just Housing Amendment. There's an investigation that's conducted by the Cook County Commission on Human Rights, and those penalties may include compensatory damages to the complainant and the attorney fees for the complainant. And there may be other fines from the commission. So you want to make sure that you are following the process for the Just Housing Amendment. If you have any additional questions or concerns, you are free to reach out to the Cook County Commission on Human Rights. All the information that I've covered, plus additional information, can be found on their website. Again, thank you for joining us for our crime-free housing training workshop. We appreciate you wanting to know and to be in the know so you can stay out of the courthouse, as I always say. Thank you, and we'll see you next time.